Good morning. Good morning. Good morning. It's Thursday. It's May 18th. I've got coffee. We've got cursey words. A lot has happened this morning. We're going to do just a quick touch in with what happened with Koberger yesterday, but I did an entire stream on that yesterday, breaking it down, and an emergency little quick bits on that. So if you need to catch up in just a few minutes, that's on my quick bits channel. There are a flurry of veritable avalanche of Supreme Court rulings this morning. I am going to touch on two that I have been following, and that is it. I have not had a chance to read all of the opinions yet, so I generally don't dig in because, well, I haven't had a chance to read all the opinions yet. So the question is going to be, Emily, what does this mean? And the answer is going to be, well, this is what they said, but I've got to think through the implications. So we're just going to touch on that real quick. And then we need to talk about Elizabeth Holmes going to prison, but we also need to talk about restitution. Then we will finally be able to get to Murdaugh, because this latest, I have read most of it. We are going to read the parts that I skipped because I looked and I went, ooh, bitch. And so I skipped stuff because I wanted to read it with you all together. So we're going to do that together because this new motion, y'all, it is something else entirely. So we're going to talk about that today too. So we've got a lot of a show. Let me know where you're coming in from, what you're drinking. Replay crew, you know I love you. The timestamps are down below as always, and I have some exciting stuff to share with you too. So I'm probably going to talk about Vanderpump Rules first though. Just to be completely transparent. I need a minute.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
I'm not okay. Are you guys okay? Vanderpump friends, are y'all all right? I don't know if I'm all right. I don't know if I'm all right after last night. I was yelling, well, at Instagram, and then at one point, my teen came in and was like, can you pause for a minute? I need to talk with you. And I was like, what? So then I paused. Not only is there like teenage stuff happening that he wanted to chat about with friends, which is always fine. Like, I'm always here to talk about teenage stuff. Really glad I'm not living it. Also glad that his teenage stuff doesn't feel nearly as dramatic as a parent as it felt when I was going through teenage stuff, when it feels like your entire world is literally crumbling. It's so dramatic being a teen. Hormones are so crazy. But they also killed off one of his favorite characters in the anime that he's watching, and he was not okay. And so I understood that he was like, this is what they did and I'm not okay. And I was like, have a seat. I'm like, this is what Tom did and I'm not okay. He's like, well, if they were together for 9 years, me trying to explain Vanderpump to my kid, if they were together for 9 years, why wouldn't he just tell her? I'm like, right? My 15-year-old is like, maybe you communicate with the people you choose to do life with. Perhaps. My kid is so funny. I just adore him. He's great. So I was just, we had that conversation. Then he watched part of Vanderpump with me, but my kid is so kind of stoic. He's like, why don't you just tell the person? I don't understand. And I'm like, well, I think Tom wanted both ways. And he's like, when does that ever work? And I'm like, right? When does that ever work, kid? It doesn't. Exactly. But I think Tom thought he could have his midlife crisis and his ride or die too, because Ariana was a ride or die for him. And he was like, I just don't feel my mojo. Boo-boo, it's not always about you. So if you want to see how I reacted to that, it's still in my Instagram stories. And it's there, but Tom's like, I can't handle turning 40, so I'm going to blow up my entire life. It's like, you need more responsibilities, because most people don't have the option to blow up their entire life when they turn 40 and hyperventilate at their boss's house. Most of us turn 40 and go, okay, do I need more therapy, medication? What is it? What is it that we need? Do we need to just a new purse? Like what is it? How are we feeling? What do we need? And then we handle ourselves. But Ariana was composed. I think one of the things that maybe was so vindicating for people who are watching this reality, and it's like a really interesting like reality that's not reality. And I have to wonder if Tom thinks everything's for a storyline, and Ariana's like, I thought this was our real life, and Tom's like, I thought this was like for the show, and Ariana's like, I thought we were like doing life together and we are on a show. And I think Tom, and we've seen this in like YouTube friend groups where some people are like, hey, I thought we were friends and we also filmed things. And then some of them are like, we are content. And when we're no longer content, you're gone, because it's content. So I just wonder if they just saw this all differently, and Tom really thought that this was all a storyline, and Ariana's like, this is my real life. But she said things that I wish I could have said in the moment when confronted with someone who has hurt me, who has cheated on me, or whatever it is, way back in the day before I met Dr. B. And so I think for a lot of people watching this, we were cheering her on, having the composure to say the things that a lot of us had wanted to say in our life. And I think that's why it felt so validating for so many. Like, you feel vindicated as she is just like, you've never even said sorry to me. You're turning around and being mad at me. It felt like, yes, I wish I could have said that. I wish I could have done that. I wish I could have been that composed in a conversation like this. It felt, I don't know. Is that weird? Maybe. But it felt kind of vindicating. And knowing that this happened and seeing how much she is thriving now felt very vindicating. I love S. Moore in the chat said 54 still getting tattoo therapy. I'm also still getting tattoo therapy, and also actual therapy, but also tattoo therapy, which I started. I mean, I got one in college. It's crooked. We don't talk about it, but it's exactly where you think it would be because of the 90s. But I started my like adult, delightful, beautiful, planned out tattoo therapy on my 35th birthday. And that's when I was like, tattoo therapy. Sometimes that's what you need. You just need a new tattoo. Sometimes that's it. That's it. You just need a new tattoo. You're just like, I need a new tattoo. Absolutely, chat. You know what it is. Those that are members have heard the story of the outfit I wore the night I met Dr. B, and how that tattoo plays into that outfit. It's as 90s as you would expect it to be. So with all of it, it was a very interesting show. I had thoughts. It's on Instagram if you want to see it. I will be doing the same thing for the reunions unless I have all the feelings and need to go live, and then it might happen. But I've been trying to tell my kids that I'm not going to pause during Vanderpump, and it didn't work. So then I was behind. So I was hopefully not giving spoilers. As you were watching, my sister-in-law's like, how are you? I'm like, don't watch my Instagram stories till you've watched the show. She's like, okay. Because spoilers. So that was my feeling last night. We're seeing Tom and Tom stuck with the, I don't understand why this isn't okay anymore. Everybody thought it was fine when we were 20. And I think we're seeing them kind of stuck in that time loop of like, why doesn't this fly anymore? And then we're seeing Ariana like literally embracing in front of our eyes that living well is the best revenge. And it's something that we can all cheer on, right? It's something that we all want. It's like, yes, wear the revenge dress, rock the revenge body, live well, get the attention that you deserve, do it. And you know that he's also seeing it because you were at the White House Correspondents' Dinner, because the entire world started talking about Scandival. And then cheers to the Bravo production team that just decided to lean in and name the episode Scandival because you had no other choice. And it was lovely. And the fact that they started, okay, I'm almost done, I swear. The fact that they started with the Watch What Happens Live that bore the restraining order that we talked about. And then Sheena talked about what happened leading up to the restraining order. I was in for it. And Sheena's like, I can't actually make a fist. My nails are too long. And I was like, oh, facts. And then she's like, I pushed her and don't know if my fingernail scratched her or whatever, but I pushed her because I was so mad. And I'm like, oh, way to own it up, Sheena. Way to own it up. Or way to own the stuff. So with that, should we talk about other people owning their stuff? Should we start with Liz Holmes owning her stuff? I think that's where we go first, right? Maybe. And then we're going to talk a little bit just briefly about the Supremes. And then we're going to talk about, we're going to talk about somebody else who just thinks of themselves in the actions that they take and don't really seem, my opinion, don't really seem to give a fuck about how it impacts everyone else. No, we're moving on from Tom Sandoval and Tom Schwartz. We're moving on from the Toms to talk about Alec Murdaugh. Emily, did you just compare dudes on reality TV to a convicted murderer? I did. Look, I'm not saying that they are that. I'm not at all. I'm just saying you can see actions where people are like, I only care about myself. How severe those actions are varies. Like your mileage may vary with all of it. So, let's quick bits it, shall we? Quick bits. Also, I saw a number of you gifting memberships, Miss Opinionated and Linda. Thank you so much. Listen, Linda, thank you for gifting memberships. Let's get to quick bits. Let's talk about Elizabeth Holmes. Liz, shall we? I'm going to do a members only podcast about my thoughts on the rebrand of Elizabeth Holmes as Liz, because I have a lot of thoughts on that New York Times article, but I'm not going to waste all your time with it here. That's going to be on I Have Thoughts because, well, it's an I Have Thoughts topic. Let's take a look at what the judge had to say, shall we? The Ninth Circuit. Let's do a quick road so far. Elizabeth Holmes was convicted 100,000 years ago after she was indicted 200,000 years ago for mostly defrauding investors. She was convicted by jury. Her co-defendant went to trial. Her co-defendant was convicted by jury. Her co-defendant turned himself into custody at the end of April. She appealed to the Ninth Circuit, which covers California and other Western states. She appealed to the Ninth Circuit. And with that appeal, the Ninth Circuit has an automatic stay. What she was asking the Ninth Circuit to do is let her stay out on bond pending her appeal. Appeals can take years. Appeals can be very lengthy. So she's like, how about you work on my appeal and I live, what did the New York Times call her multi-million-dollar beachfront mansion? Her quaint, I believe quaint was the word. Cozy? I think it was quaint. Her quaint beachfront mansion. I stay here in my quaint beachfront mansion in San Diego, and y'all do the appealy things. See, when the Chrisleys did that, what the court said was adorable. You can appeal. You're going to wait in prison while you do that. And I think the Chrisleys have a stronger appeal than Elizabeth Holmes does. You have to show the court that you have a really good chance that your appeal might overturn or at least garner you a new trial for them to consider you staying out of custody. Or your custody time has to be so short, Jussie Smollett, whatever, Raquel, Rachel, same. You have to show that your court ordered sentence is so short that by the time your appeal gets done, you would have served all your time and then there's no remedy. So Elizabeth Holmes was like, what I'd like to do is like stay home and not go to prison while you all sort out the appeal. And because the Ninth Circuit rules are that an automatic stay happens, it automatically stopped the date she was supposed to turn herself into prison and bought her an extra, 2 weeks. The Ninth Circuit, Monday, was it Monday? What day is it? Are we Thursday? Maybe it was Tuesday. The Ninth Circuit earlier this week said, no, we're not going to let you stay out on bond pending appeal. You don't meet the criteria. So the lower court said, go to prison. They're like, hey, boo-boo, it's time to go to prison. Order granting Ms. Holmes' unopposed administrative motion to set a new reporting date, so her stay was denied. Having considered Ms. Holmes' motion, the court orders defendant Holmes will be required to report to the Bureau of Prisons on May 30th, no later than 2 p.m. She still has, what is that, another 2 weeks? Let me take a look. I mean, yeah, she still gets herself another 2 weeks. She's like, can I not go yet? So May 30th is supposed to be her turn-in date. She has asked to go to the same prison camp as Jen Shaw. Do you think they'll start a business together? I have questions. How's that going to go? Are Jen Shaw and Elizabeth Holmes going to become besties in prison? Because Elizabeth Holmes has an 11-year sentence. I mean, she's going to be in longer than Jen Shaw will be. But I want to know. I think it might happen. I think these two might be friends. Oh yeah, Elizabeth Holmes has been trying to put this off much longer than Martha Stewart. Martha Stewart was like, well, this sucks, and went to prison and served her time and got out and is now on the cover of Sports Illustrated swimsuit. Like, Martha Stewart has absolutely turned going to prison around and made it work for her in a way that I've never seen anyone do. Because she's Martha Stewart. She's so funny. Yes, Martha Stewart being besties with Snoop Dogg is like one of my favorite things that exists in the world. And the fact that they have the 19 Crimes wines together is so good. I think Martha Stewart has spent more time in custody than Snoop Dogg has. Like, by a lot. All right. Let us continue on. So that's Elizabeth Holmes. She's going to jail. Prison. Apologies. Finally. This has been years and years and years in the making. Yes, she's still going to appeal. Do I think her appeal is going to go anywhere? Probably not. Yes, she will still appeal. Let's talk about the other loss, like the other L for Elizabeth Holmes here. Let's talk about her restitution order, shall we? Why? Because I like big numbers and I cannot lie. Well, when they're not mine. It's all fun and games when it's other people's money, right? Order on restitution. This matter comes before the court to determine the amount of mandatory restitution owed to the victims by Holmes and Balwani as a result of their fraud and conspiracy convictions. Having considered the parties' written submissions and oral arguments presented at defendants' respective hearings, the court orders restitution in the amount of $452 million. Remember, the government was asking for $900 million. Both defendants will be jointly and severably liable for this sum, meaning if Sonny Balwani pays $1 million, then that takes $1 million off the total. This is a total owed by both of them. They both have to pay it, and they are both responsible for it. $452 million. And you know what Elizabeth Holmes is probably going to do is say, I don't have anything. I'm in prison. I don't own anything in my name. And since her partner seems to be a millionaire, she will probably just never get married so that no one can attach his property, and he will pay for everything, and she'll say, I'm judgment proof. I have no money. Because she's already lost her stock options. For those of you that are newer law nerds, it was in a motion that she's been punished enough because she lost her stock options. That motion was one of the least self-aware things I've ever said. And I'm caveating that because we're going to talk about Murdaugh in a little bit. But she's lost her stock. She's lost everything. She's lost her company and her good reputation. And people hate her more than Osama bin Laden. Like, seriously. So do I think she's going to try to pay the $452 million? I don't think so. Hamilton in the chat made a good point. I believe they have a $150 million house in Silicon Valley, but whose house is it? Because I think it is her partner's family's house, and the government cannot go after her partner's money. They are not married. And I don't think they will ever get married because of this. I think she will stay judgment proof with nothing to her name, and he will own it. So she does not own anything. She is sustained by her partner and will not own anything. So, Kat in Virginia said, was her company really worth anything well, isn't that the thing with fraud? Was it ever really worth anything? Or was it all just hype? Her investors invested hundreds and hundreds of millions of dollars into the company. So at one point it had a very high valuation, but was it actually worth anything? Well, what is hope worth? And what does it cost you? I think it was the hope that they would make money, but the expectation that they might not. It's kind of like, what's crypto worth? What are stocks worth in general? With a company with any company, what are stocks worth in general? They go up, they go down, they fluctuate. People invested into Theranos, well, based on fraud in part, but also based on, if we get in now, we have the opportunity to make a ton of money. They took a gamble on Elizabeth Holmes and lost. I don't know, at least in Vegas, you kind of know it's stacked against you, right? This is why I don't gamble in Vegas, I shop. At least I know what I'm getting. If I'm giving you my money, I want to know what I'm getting in return. It's normally a purse or alcohol. Is Sunny Balwani in prison now? Yes, he is. Elizabeth married that guy in 2019. I don't know if they're married. I know they're together, but I don't know if they're legally married. They could have had a civil ceremony or a ceremony where they got married, but did not file paperwork to be married with the state. I don't think they are lawfully wed. I don't think that is lawful law. You can have a wedding ceremony. I mean, Tana Mojo did it. You can have a wedding ceremony and not be married. So, love Vegas shopping. Oh my God, so do I. I do tend to go to Vegas with friends who don't let me shop after I've been drinking, because impulsivity and sometimes I'm like, oh, this is a brilliant idea. No, it's not. I assure you that it's not. Sobered decisions. A spiritual wedding. Exactly. So they might have, they could do that. They could do like a commitment thing, and you could stage a wedding and not be married, i.e. Tana Mojo and Jake Paul. You have to sign the marriage license to be lawfully wed. You can also be lawfully wed without staging a big wedding. So with all of that, does the state recognize common law marriage? No. They're in California and it does not. Oh no. California absolutely does not. I imagine there's a lot of reasons for that, including the wealthy inhabitants of California who are like, no. What you're not going to do. Wait. Kind of like Katie and Schwartz. Katie and Schwartz never turned in their marriage license. Did they ever get it turned in? Maybe they didn't actually have to pay for the divorce because they weren't lawfully married. Because Schwartz never turned in Schwartz and Katie's marriage license. I remember that being a plot line. It all comes back to Vanderpump today. All of it. The second wedding they did, they turned it in. So they turned it in at the second wedding just in time to turn around and have to get divorced. That kind of sucks. It's like, the second wedding on any reality show or a commitment ceremony or a renewal of vows is always the kiss of death. Always the kiss of death. Don't do that. Let's talk Okay. Thanks. Thanks, Siri. I appreciate your input on that. Oh my God, just me in the chat said, it's not about the pasta. It was never about the pasta. But when it comes to the vow renewals, it's over. It's over. Over. All right. Let's talk about Google real quick, shall we? Hold on. Where is it? Here it is. Google versus Gonzalez. No. Gonzalez versus Google is a Supreme Court case that I touched on a little bit. It was seeking to have the Supreme Court evaluate Section 230. The Supreme Court evaluated this in regard to a Twitter case as well. Both cases were similar. The Twitter case and the Google case were kind of companion cases, both in different ways asking the court to evaluate Section 230. And what the court essentially did was uphold Section 230. So the algorithm is not changing. The Google case, the court kind of punted on it and said, hey, we already decided in the Twitter case. And also we don't find a cause of action for which relief can be granted. So for those of you asking what Section 230 is, Section 230 is part of the Communications Decency Act of 1996 that was created, and I've had a number of videos on this. It's been a while. If I find anything that we need to go over in this, maybe I'll do a podcast episode on these and kind of go through again what these mean for 230, what 230 is. But the very base level principle of Section 230 is that a service provider, ISP, whoever, Twitter, Google, Yahoo, Tumblr, whatever it was, because this was 1996, it was mostly like listservs, can't be sued for the shit other people say. Reddit. Where else are people unhinged? Kiwi Farms, whatever else. People do and say unhinged shit on the internet. On Twitter, on Reddit, on wherever. But person who is harmed by that or defamed by that or whatever cannot go sue Reddit or Twitter or YouTube or whatever for the things that people said. So if you have a YouTuber who is defaming Cardi B on YouTube, Cardi B can't sue YouTube and be like, YouTube, look at this shit that you're allowing on your platform. You are hosting this shit on your platform. You are the speaker. So therefore, I, Cardi B, am going to sue YouTube because you're Google, you're Alphabet, all the money. I'm assuming that Google and Alphabet as companies have more money than like Tasha K. So wouldn't you rather just sue the company? The thought was for the internet to exist if the companies were held liable for the things that people said on the platform, that the companies would never exist. I think this is the government saying, well, the internet's going to internet. And you can't sue the company based on what people say. You have to go sue the people. Go find the people, sue the people. That is the basis of the kind of underlying premise of Section 230. There are some exceptions to Section 230 that also protect companies for the way that they choose to moderate that and what they choose to take down or put up. So you also can't sue the company for yeeting you off the platform, even if you think it's unwarranted, if that makes sense. So tandem cases came up for Twitter and for Google over I can't even say it on platform. Oh, well, we're demonetized. Go buy lip gloss for terrorist acts. And the lawsuits allege that the propaganda that was allowed to remain on the platforms are what caused the individuals to take the actions that they took that caused the harm and death of the individuals whose families are suing. So with all of that, they went to sue Google saying your algorithm contributed to this. And because your algorithm contributed to this, we're suing you. And so that was part of it. The court breaks down the claims very well and says in 2015, ISIS terrorists unleashed a set of coordinated attacks across Paris, France, killing 130 victims, including Nomi Gonzalez, a 23-year-old U.S. citizen. Gonzalez's parents and brothers then sued Google under 18 U.S.C. 2333A and D2, alleging that Google was both direct and secondarily liable for the attack that killed Gonzalez. So trying to hold YouTube and Google responsible for the actions of others because of content that was on the platform. The Supremes go on to say, we granted cert to review the Ninth Circuit application of 230. Plaintiffs did not seek review of the Ninth Circuit's holding regarding their revenue sharing claims. In light of those unchallenged holdings and our disposition in the Twitter case, on which we have also granted cert, and in which we today reverse the Ninth Circuit's judgment, it has become clear that plaintiffs' complaint independent of Section 230 states little, if any, claim for relief, as plaintiffs concede the allegations underlying their secondary liability claims are materially identical to those at issues in Twitter, right? They are twin cases. Since we hold that the complaint in that case fails to state a claim for aiding and abetting, it appears to follow that the complaint here likewise fails. So they are kicking this on other grounds. We need not resolve either the viability of plaintiffs' claims as a whole or whether plaintiffs should receive further leave to amend. Rather, we think it's sufficient to acknowledge that much, if not all, of plaintiffs' complaint seems to fail under either our decision in Twitter or the Ninth Circuit's unchallenged holdings below. We therefore decline to address the application of Section 230 to a complaint that appears to state little, if any, plausible claim for relief. They punted. Instead, we vacate the judgment below and remand the case for the Ninth Circuit to consider plaintiff's complaint in light of our decision in Twitter. So this is not done yet. And the Twitter complaint is going to carry more weight. I have not read through the Twitter complaint, but I have the article from Law 360 that I think will be helpful if we go through together. Because Section 230 absolutely impacts how we internet. And there are bigger conversations to have here. I don't want to get into an everything problem. This is supposed to be quick bits, and we've got a lot of Murdaugh audacity to get to. But there's a lot of conversation to be had around 230, what is and is not okay. Can someone yeet it off a platform, sue the platform for the yeeting? At what point do you have any recourse against platforms at all? But when is it too broad to sue a platform for everyone someone says on the platform? You know, someone's like, she's a lawyer with purple hair, I'm suing Google. I'm offended by her face. Like, at what point is that too far afield? And these are the conversations that need to be had, because Section 230 was made in 1996 when our perception of the internet was so different than what it is now. So I think there's room to continue to have conversation about Section 230. The Supreme Court seemed disinclined to acquiesce to that request to have the conversation. So let's look at Law 360's breakdown of this. I have not had a chance to read all of this yet. The U.S. Supreme Court on Thursday threw out a lawsuit saying Twitter violated the Anti-Terrorism Act by aiding and abetting ISIS, saying that the terrorism, I've now said that like 17 times, we're definitely demonetized. You know what? This is why we have an amazing community, because it just doesn't matter. It'll be fine. Like, it'll be fine. We have members, we have sponsors, we have collaborators, and it doesn't matter, which is a really nice and freeing thing. It's like, no, I want to talk about this. I can talk about it. I don't care if it's platform friendly. It's fine. It's not really that it's not platform friendly. It's not super advertiser friendly, even though the context is educational. So we just don't care. We do what we want.
I do what I want. I do what I want. We're going to talk about it. So all the little robots that are going to get mad because I keep saying ISIS. I get it. You're mad. Fine. Context.
Okay. So, The Supremes decided that the underlying act was not plausible, but did not decide the closely watched question of immunity for big tech companies under Section 230. So they punted entirely. Like, you can't sue that way. This is when I say appellate courts and the Supremes love a technicality, they love, like, Idaho's the perfect example of this. Hey, we're not going to decide your question, but what we're going to say is that you don't have original jurisdiction, or we don't have original jurisdiction here. So because we don't have original jurisdiction, we're not actually going to answer your question. They are the absolute kings and queens of sidestepping the question. Yeah, so there's this huge question that you want us to answer. But before we get to that, there's this procedural thing that means we can't answer it. So we're not going to answer your big question. And they do this all of the time. All of the time. And then we get these weird little rulings on procedural grounds. So they sidestepped 230 entirely, it seems. It's not the last time. This will keep coming up. You know, though, if our government functioned the way it should, the legislature could just fix it by, like, writing laws that made sense. But that's a whole nother conversation about the function of government working properly. We're not going to go there today because we do not have the time or the bandwidth. These are not our problems. We have lip gloss. In a pair of decisions addressing terrorism-related claims against Twitter Inc., Facebook Inc., and Google, the High Court focused on whether the victims of terrorism had made a plausible claim for relief under the Anti-Terrorism Act. In a unanimous decision written by Justice Clarence Thomas, the court said tech companies' conduct did not constitute aiding and abetting because they did not knowingly provide substantial assistance to the groups. Technicality. Tech companies cannot be held liable for merely creating platforms later used by such groups, nor setting up algorithms that display content relevant to what individual users might have sought out. Look, the amount of content that Google has served me lately on, like, 30-day walking challenges has actually made my life better, and I am here for it. You can train your algorithm to be a positive place. You just have to keep clicking on the same shit. And then you find yourself down a rabbit hole learning about YouTubers that live in the northmost town in the entire world, like basically at the North Pole. And you're like, wow, that's fascinating. And I love it. Positive place. Positive place. So they sidestepped the entire thing in the 3-page decision. In the 3-page per curiam decision, this is the addendum, the court said it was declining to address the question of whether the Ninth Court properly applied Section 230. Section 230 to the Supreme Court. Hey, everyone would like you to address this. The Supreme Court, we are disinclined to acquiesce to that request. We don't think you've stated a claim for relief. Bye. Thanks for clearing it up. People have been watching this case with substantial effort. Let's talk about the bigger thing they did today, shall we? And then I promise we're going to go talk about Murdaugh, because the Prince Warhol case got decided today too. When I tell you that my morning was me going to, like, I don't look at my phone first thing in the morning. I wake up and try to, like, you know, I wake in the morning and I step outside and I take a deep breath. Yes, this is my morning. I try not to get on my phone. I go to Starbucks this morning, had a nice little morning, decompressed from a lot of content yesterday. And then by the time I look at my phone, I'm like, oh my fucking God. The Supreme Court dropped a million opinions. Yes. Cecilia, Christopher, and Grimm. Yes. So far down the rabbit hole. Love it so much. Love the content so much. It's so wholesome. I absolutely love it. It's so great. Wholesome content. There is plenty of wholesome content to be had on the internet. You just have to find it. And then the algorithm's like, oh, you like to see people having a lovely day with their dogs. Yes. Guess what the algorithm will serve you? More dogs. Train the robots to work for you. It's just, I love, like, slice of life. YouTube. Anyway, you know this about me. So, Supreme Court also ruled on the Prince Warhol case. Let's give a quick road so far of this case. I'm going to try to do this real quick. There is a famous photograph of Prince that Andy Warhol turned into a painting. The photographer sued over the copyright in the photograph. Look at this photograph. I couldn't help it. It had to happen. And the Supreme Court needed to take a look again at fair use and copyright. At what point is a work transformative enough? I have not read this entire opinion. We are going to look at the Law 360 article. I am going to read this opinion more because this is going to impact creators. So, did Warhol's painting of Prince transform the photograph? My brain is so ADHD today. Hold on. I'm trying to find the two together. All right. I have anger at the New York Times, but they have the best image. Photograph painting. Is the painting transformative of the photograph? And there were quite a lot of arguments over whether or not the painting was transformative of the photograph. And this is evaluated under copyright. Well, let's go to what the Supreme Court did. I will go through this opinion more because the Supreme Court says that Prince's series is not fair use. Andy Warhol's portraits of music icon Prince do not fall under the copyright's fair use doctrine. Do not. It is not transformative. Affirming the Second Circuit's decision finding that Warhol's work shared the same commercial purpose as the original photograph taken of Prince. This is not how I thought that this would go. Truly. In a 7-2 decision, the High Court sided with the photographer on the argument that Warhol did not make fair use of her copyrighted photograph of Prince. Do you know who's celebrating this? The Black Eyed Peas. Well, their music label. Because this is going to fuck the Poopsie Slime Surprise case. Sorry, Poopsie Slime Surprise. Go offer money immediately. That's not legal advice. In a 7-2 decision, the High Court sided with photographer Lynn Goldsmith's argument that Warhol did not make fair use of her copyrighted photograph of Prince, upholding the circuit court ruling that the artwork in question was infringing. It was an infringing derivative of the original. The Andy Warhol Foundation had argued that Warhol's artwork was transformative of the photo because the artist gave new meaning to the previous work. But the justices were unpersuaded, finding that, quote, although new expression may be relevant to whether a copying use has a sufficient distinct purpose or character, Warhol's Prince did not have a sufficiently different purpose from the photograph taken by Goldsmith. This is going to have a very large impact. A large impact on fair use, art, derivative art, AI art, music, tattoos. This kind of stuff always happens. This stuff comes down to tattoos too, whether tattoo artists who use a photograph or a logo or whatever, whether they're infringing. As portraits of Prince used to depict Prince in magazine stories about Prince, the original photograph of and AWF's copyright use of it share substantially the same purpose. Justice Sotomayor wrote for the majority. The last time the court tackled the question of whether creative work constituted fair use under the federal copyright statute was 1994, when the justices held in Campbell versus Rose Music that a work is transformative if it adds something new with a further purpose or different character, altering the first with new expression, meaning, or message. The underlying dispute was triggered by the foundation, which sued in 2017. During oral arguments in October, the High Court justices seemed focused on how the court should decide whether an artwork qualifies as fair use. This is going to come up in the Jack Daniels dog toy case as well. That has not been decided yet, unless it came down and I didn't see it, but I don't think that's been decided yet. So this is not fair use. I am going to go through this opinion and see how this changes fair use, because this opinion has now given new context to the prong of commercial purpose for fair use. And we will see. And how much will this, and what will this affect? So that is a quick bit. This is going to be a very big decision that lawyers are going to be poring over to try to figure out what they mean. But fair use is still kind of the Wild West. Remember, fair use is a defense. So this, it's funny because I did a podcast with Pat Flynn not that long ago about fair use. And I was like, there's cases coming that are going to change this. 3 weeks later, welp, it's a little bit different. So I will be going through this opinion just for my own interest and for fair use. Let's see how long. 87 pages? Come on. I mean, granted, it's in the weirdest font ever. I hate the way the Supreme Court does this. 87 pages later. So thank you, Supremes, for putting pictures in your opinion. We appreciate you. I'll read the opinion just for all the pictures of Prince. I'm here for that. These opinions are public, so if you want to read it, you can Google it. It does have 3-inch margins, but 87 pages. The font is so fucking small. That's why I hate reading Supreme Court opinions. They hurt my brain. Oh, of course it's here. Of course it is. Of course it is. All right. So I will be reading this and giving you more of my thoughts. I don't know when I need the Murdaugh to calm down so I have time to read this. Yes, the margins are big to write notes. Why is this the Supreme Court's font of choice? I don't know. This is also all the additional opinions. Everybody has a say in this. I don't know why. I don't know the history of the Supreme Court using these fucking ridiculous margins. It probably has something to do with the way that the Register was printed a million years ago. But it is about Prince, and I enjoy that. Oh, wait, why? Oh, they're talking about the photos of Marilyn Monroe too. Okay. This is how I peruse an opinion, and I love that there's photos. So I'm here for the photos. All right. We will get back to that. I have thoughts. I'm very interested in how this is going to change the fair use analysis. And this is sending me back into research attorney vibes where I'm like, I need to read it. I need to look at what does the fair use analysis look like now? And how does this change the fair use analysis? How are courts going to apply this? Because now that there's this ruling by the Supreme Court, the other courts have to take this and then try to apply it in their opinions. And then they're going to apply it differently. And then it's going to split again. And then it goes back up to the Supreme Court. And that's how that all works. Did I have anything else I was going to talk about this morning? I think that got us there. An hour in. I think that got us there. I'm invested too, Jessica. I'm going to break this down. What does that do for previous paintings of Warhol? It calls them all into question, but I don't know if any of those are past the statute of limitations. I don't know if it will open a floodgate of litigation. I don't know, but it is a loss for the Warhol estate. And I don't know what happens now. So this will be very interesting. The AI art lawsuits is where I see this going next. But what I want to do is take a look at what this means for the fair use analysis. what this, because video creators use fair use for things all the time. I try to stick to things that are pooled so it's very clear. But we'll see. So the fair use analysis again has some new input, and I'm very interested in that. And I will be covering it. All right. We need to talk about Murdaugh. Let me pull up my notes because I'm a professional. And I was gripped by the amount of Supreme Court rulings that today. They tend to do that. Multi-creative entrepreneur here. Thanks for this. You're welcome. There's a question here. There's a question here of which prong of fair use becomes more important and how and when. And I will be looking into that question. But again, it needs more thought. But they did determine that this was not fair use. And that is a big decision that is going to have ramifications. Just know that it's out there. Let's stretch. I think we need it. Y'all hydrate. It's time to hydrate. It's just, we need to gather ourselves for this shit. That's what we need to do. We need to gather ourselves for a minute. That's what I needed to do. That's what I needed. I needed to cleanse. Here, look. We all. All right, just everybody take a deep breath. Or fill your spirit with the rage that you're still carrying around from last night's episode of Vanderpump, one or the other. We need to talk about Murdaugh. Alec Murdaugh. Richard Alexander Murdaugh. Dick Murdaugh, if you will. Represented by his attorneys, Dick and Jim. So Dick, and Jim have filed a motion in the Satterfield case that is something. Did y'all catch the podcast yesterday? I feel like we've lived 100 years since yesterday morning when the podcast dropped, and then there was an indictment in Idaho. And so maybe you haven't caught the podcast from yesterday, but yesterday's podcast, I go through what's going on in the insurance case and what's going on in the Satterfield case. The Satterfield case had largely been resolved. Why? Well, let's take a look. We're going to go back through the history just a little bit because it matters. Normally I do a road so far if I can when it doesn't, but we need a full briefing on this. Well, a quick briefing. This was filed September 1st, 2021, September 15th, 2021 by Bland Richter from the Satterfield sons. Sometimes I call them the Satterfield boys. I know they are adults. However, they are Gloria Satterfield's sons. They will always be her boys. And so sometimes I call them the Satterfield boys or the Satterfield sons. But these are the Satterfield sons sued Alec Murdaugh, Chad Westendorf, Palmetto State Bank, Corey Fleming, Moss, Kuhn, and Fleming. Corey Fleming's prior law firm. This complaint, Nightbot would fucking hate. Nightbot would be like, excuse me, Bland Richter? Emily asked that you not do all caps. Nightbot would be like, no. Nightbot would yeet this immediately. Gloria Satterfield fell in the home of Alec Murdaugh and later died on February 26, 2018. Following her tragic death, Alec Murdaugh introduced Gloria's grieving sons to Alec Murdaugh's good friend, Corey Fleming, so that Fleming could assist the sons in filing legal claims against Murdaugh for the wrongful death of their mother. With the assistance of a banker friend, Chad Westendorf, claims were purportedly brought against Alec Murdaugh. Thereafter, Alec Murdaugh stipulated that he was at fault for the death of Gloria Satterfield, and his insurance company paid $505,000 in settlement of the claims. That insurance company is Lloyd's of London, not Nautilus. Nautilus is the insurance company that is suing Alec Murdaugh in the insurance case, where Alec Murdaugh has now said that Gloria Satterfield did not get tripped by dogs, that he defrauded his insurance company, and that he stole the $3.3 million that the insurance company paid. This is a different settlement. This is the settlement with Lloyd's of London that sparked everyone looking into this, because Mandy Matney found the settlement, reported on it, and went, excuse me, what? What is this? The Satterfield sons did not know that a settlement had been reached when that was found. To date, the children of Gloria Satterfield had never received the first dollar. This is before the rest of it was known. The plaintiffs are victims. The plaintiffs are vulnerable. The plaintiffs are scared. By this action, the plaintiffs seek real answers to their questions surrounding the death of their mother and the disposition of money supposedly paid for their benefit. This is September 15th, 2021. This is before they knew how deep this went. There's a second amended complaint. Or there's an amended complaint. Sorry, it's a FAQ. We're going to look at the FAQ real quick. The FAQ is from December 6th, 2021. From Tony Satterfield individually and as the personal representative of the estate of his mother and then his brother versus Richard Alexander Murdaugh and Bank of America. Everyone else has settled. Introduction. Oh, thank God it's not in all caps. As detailed herein, Bank of America acted as Alec Murdaugh's bank of fraud. God, they love those all caps and the snappy one-liners. Bank of fraud. They have renamed Bank of America to Bank of Fraud. Specifically, BOA or BOF. Not BOA, Bands Across America. Wait, Bands Over America. Isn't that BOA? Isn't BOA still Bands? Either way, Bank of America, Bank of Fraud, whatever. Specifically, BOA aided and abetted Murdaugh's financial crimes and money laundering, footnote 1. On November 18th, 2021, Murdaugh was issued 27 indictments for financial crimes, 9 of which pertained to the plaintiff's money, including counts for money laundering $403,000, money laundering $2.9 million, and money laundering of $118,000. Money laundering. By flexing their own rules and ignoring banking customs, BOA helped Murdaugh establish his fake forge accounts. Murdaugh funded with stolen money from plaintiffs as well as other victims and or PMPED clients. Footnote 2, Parker's, Murdaugh, Parker's, Elstroth, and Dietrich. It's no longer in existence. This was before PMPED disbanded. Once he was in possession of his ill-gotten gain, Murdaugh engaged in other suspicious banking conduct with BOA. With BOA, but that should be which BOA should have identified. For example, one of Murdaugh's fake BOA accounts, he issues 17 cashier's checks to Charles E. Smith, aka Cousin Eddie, totaling $164,000. Footnote 3. These cashier's checks were issued between October 8th, 2019 and May 28th, 2021 from the fake forge account as is described herein. In addition, Murdaugh transferred huge sums of stolen money from his fake forge accounts to a personal checking account, which Murdaugh also established at BOA. From one such account, Murdaugh separately issued 254 personal checks to Cousin Eddie, totaling $1.8 million. Maybe Murdaugh should ask Cousin Eddie to pay for his appeal. BOA was the last clear chance to stopping Murdaugh's criminal activities. Instead of acting as a good corporate citizen, BOA chose to cash in on his crimes. To be clear, BOA made significant fees from Murdaugh's accounts, presumably loaned money based on his stolen deposits, and collected interest on the same. But what is truly unbelievable is that even after Murdaugh's fraud and theft was exposed, BOA failed to terminate Murdaugh as a customer. They did not terminate him as a customer. Upon information and belief, Murdaugh may have been a BOA customer as late as November 23rd, 2021. This is the second amended complaint. These complaints are Gloria Satterfield's sons against Murdaugh regarding fraud. The causes of action here are let's get to the causes of action. We know the history of Murdaugh's fraud, and we know that he's now admitted the fraud. Where are the claims? Sorry, I'm trying to get to the claims. Where are the claims? We have not done a deep dive into this case. If we need to, we will. I wanted to get to the newest answer. First cause of action for an accounting. Hey, show us where the money is. Second cause of action between Murdaugh and BOA for civil conspiracy. The conspiracy being to steal the money from the settlement. Third cause of action, aiding and abetting breach of fiduciary duty. Whose fiduciary duty? Murdaugh's fiduciary duty? I'm curious about whose fiduciary duty this is. Upon information and belief, BOA knew Murdaugh was a lawyer. Upon information and belief, BOA knew that the forged deposits represented money that Alec received in his capacity as a fiduciary. I don't know if they'll be able to prove that. This doesn't matter, truly, if they can prove this or not. I'm just trying to get a lay of the land for the causes of actions. BOA aiding and abetting Alec Murdaugh's fraud. BOA negligence, gross negligence for not catching the fraud. Sixth cause of action is to BOA SCU TPA. The plaintiffs are entitled to damages against Bank of America and a sum sufficient to compensate plaintiffs for their damages, but not less than $4.3 million. Seventh cause of action is to BOA negligence per se under case law. Legal malpractice, breach of fiduciary duty to Murdaugh. So that's his malpractice claim. And that is the end of the amended complaint. Now, you will recall that Alec Murdaugh, before the murder trial, signed a confession of judgment. We learned last week that in Eric Bland and Bland Richter's press conference, that the $7.5 million that have been recovered by the Satterfield sons have been paid by all those other defendants, right? Have been paid by BOA and Palmetto State Bank and Corey Fleming and Corey Fleming's law firm and Chad Westendorf and the rest of them. Alec, Dick, if you will, Alec had signed a confession of judgment, but not yet paid. That confession of judgment was entered into on May 31st, 2022, almost a year ago. And Alec confessed judgment in the amount of $4.3 million as a pre-judgment settlement to settle these claims. Confession of judgment. He confessed that he's a citizen, that he admits liability. Debtor, Murdaugh, admits liability to judgment creditors for claims asserted against them in civil action 2021 CP 25 00298. So we are clear that is the complaint that we are talking about. 00298, the complaint I just brought up. He is confessing judgments. Debtor admits liability. It's like testifying, but on paper. Debtor and judgment creditor hereby acknowledge, agree, and stipulate that this judgment is subject to and restricted by the receivership implemented. We talked about the receivership in the podcast. Debtor confesses and authorizes the entry of judgment in favor of the Satterfield sons in the amount of $4.3 million. And then they talk about how the payments are going to be made. He confessed judgment. Do you remember this coming up at trial, chat? At trial, he talked about the fact that he admitted to this. This was one of the things. Do you remember? It's such a Tom moment where Tom's like, well, if Ariana had just stalked me and followed me home, she would have seen that I was cheating. And she's like, I would have seen you were going to Schwartz's. He's like, well, at trial, he was like, but I admitted to this wrongdoing and I admitted to the other financial crimes wrongdoing. I didn't do the murder. I admitted to all this other shit. Remember? I admitted all this. I just didn't do that. So yes, I'm a liar and this and this and that, but I didn't kill Mags and Paul. which makes me wonder if this was all a strategy so he could argue it in the murder case. Just a thought. Is he playing the long game? I don't know. But on May 16th, 2023, defendant Murdaugh motioned for judgment or motion for relief from judgment. Hold on to your butts because this is a wild ride. Other movie quotes. We're going to need a bigger boat. The audacity. What the ever-loving fuck. I've got a bad feeling about this. Defendant Richard Alexander Murdaugh, through undersigned counsel, pursuant to Rules 60B3 and 60B4 of the South Carolina Rules of Civil Procedure, hereby moves for an order vacating the judgment confessed by Murdaugh in favors of the plaintiff on May 31st, 2022. Vacating means yeet. He wants the court to yeet the confession of judgment that he made. Yeah. If y'all know where hold on to your butts is from, you're welcome to put it in the chat. It's something that my husband and I say all of the time. If we go code red now, we have nowhere to go when it gets worse. So I'm taking the motion under submission. I'm taking the motion under submission. Because if we go code red now, we have nowhere left to go. We can't get there yet. Oh, God, I love you, Chad. At Jurassic Park, indeed. Introduction. Yeah, it gets worse. Oh, it's going to get a lot worse. No, this is not the worst part. This is the preamble to bad. Get black lights. I need to. Introduction. Defendant Dick Murdaugh was a lawyer, disbarred lawyer, and formerly a partner at the law firm PMPED. Remember, this is being written by Dick and Jim. Well, and Dick. Dick and Jim. Dick, Poot, and Jim are writing this. Following the murder of his wife, Maggie, and son, Paul, on June 7th, 2021, Murdaugh's opioid addiction spiraled out of control. Also during that time, PMPED began to investigate missing funds from Murdaugh's cases. On September 3rd, 2021, PMPED confronted Murdaugh about the missing fees. Well, that also happened on June 7th, but on September 3rd, 2021, they're like leaving out facts. On September 3rd, 2021, PMPED confronted Murdaugh about the missing fees. He was confronted before that, but whatever. Murdaugh admitted to misconduct and resigned from PMPED. The following day, Mr. Murdaugh was shot in the head by Curtis Eddie Smith, his drug dealer, in a failed assisted suicide attempt. Mr. Murdaugh thereafter began inpatient drug rehabilitation. On September 15th, 2021, warrants were issued in Hampton County for his arrest on charges of insurance fraud, conspiracy to commit insurance fraud, making a false police report, all arising from the failed suicide attempt. Well, now I've said all the words that the YouTube hates. Also on September 15th, 2021, this action was filed. Plaintiffs allege defendants conspired to steal proceeds from the settlement of claims arising from the death of Mr. Murdaugh's longtime housekeeper, Gloria Satterfield, at Murdaugh's Colton County residence. The original causes of action asserted against Murdaugh were equitable accounting, civil conspiracy, and conversion. The original complaint did not allege Mr. Murdaugh's dogs caused Gloria Satterfield's fall, or that Mr. Murdaugh told anyone the dogs caused her fall. The operative second amended complaint asserts causes of action against Mr. Murdaugh for equitable accounting, civil conspiracy, legal malpractice, breach of fiduciary duty. It alleges, quote, according to the Murdaughs and as reported to Gloria's family and others, Gloria's fall down the exterior stairs of Murdaugh's Moselle, South Carolina home in Colton County was caused accidentally by the Murdaugh's dogs. Mr. Murdaugh confessed judgment to plaintiffs on May 31st, 2022. Defendant now moves to vacate, yeet, remove, undo, unwind, delete that confessed judgment under the rules because of, quote, other misconduct by plaintiff's counsel in respect to this matter. And under Rule 6b4 or 60b4, because the confession is void under South Carolina law, as discussed in more detail. Oh, it's 27 pages. There's much more detail. As discussed in more detail below, and for further and additional reasons that will be presented at the hearing on this motion. Oh, can't I wait to see that? The judgment should be vacated because it fails to comport with the requirements of South Carolina law, because it was based on inaccurate facts. Whose facts? And because the judgment does not serve and was not obtained for any legitimate purpose. Whose legitimate purpose? Mr. Murdaugh makes this motion to correct these errors and set the record straight about the events underlying this action. Background. Oh, yes. Given the complicated nature of the underlying facts of this case and their relevance to this motion, defendant provides the following timeline of relevant events. So this is the defendant's timeline of what the fuck happened. Okay, let's see. Let's see what's left out. Chat, feel free to jump in on what's left out. These aren't acting like lawyers and aren't getting paid. Just an observation. February 2nd, 2018, Gloria Satterfield faints. Really? And falls down the steps at Moselle in Colton County. Now she fainted. How do you know? How do you know? How do you know that? Because in the interview we listened to last week, Murdaugh said it was the dogs. Murdaugh said that Gloria said it was the dogs. Murdaugh's now saying he's lying about that it was the dogs, that he made it up. But how do you know she fainted? Is it another lie? On what facts are you basing this allegation? Is this pure conjecture and speculation? How do you know? Gloria Satterfield faints, they say, and falls down the steps at Moselle. On information and belief based on the subsequent investigation of her death by Mr. Murdaugh's insurer, Ms. Satterfield's medical conditions and side effects of medications taken for those conditions caused her to faint and fall down the stairs. Where? Because if the insurers determined that she fainted, why the fuck would they pay out $3.3 million? Why? One thing I know about insurers, and I have not worked in the insurance industry, this is just life experience. Chat, let me know what you think. Is that if they don't have to pay, they're not going to. Am I crazy? If they say that this is an accidental fall based on her medical conditions and medication, they're going to say, we are so sorry. They might not even say that, to be honest. But we are not responsible here. We're not going to give you $3.3 million based on a faint or a side effect of medication. So how are you telling me in this legal filing that the insurers determined that it was side effects of medication that caused her to faint and fall down the stairs, when the insurance investigation seems to say that Murdaugh is saying it's the dogs, and therefore we need to pay out because it is the dogs, and he is saying that he is at fault to get us to pay out? But I think the argument is that that was all fraud on Murdaugh's part. But this does not say the insurance company determined the payout based on his fraud. This says that the insurance company determined it was based on her medical conditions. Why did they pay then? Isn't it like, I don't know. Am I basing this on The Incredibles? Maybe. Isn't it their job to find ways to not to pay? And if this was an accident, they're not going to pay based on all the exclusions in those claims or and we went over the policy, a week ago, 2 weeks ago? Time is a construct, but there were a lot of exclusions. And they would not have paid unless the homeowner was at fault. So now, Chad, as I have taken the motion for code red under submission, it's going to get worse, but I feel like now is the time to go code red. What do you think? Yeah? The bumper, by the way, is a little bit flashy. So if you are flash sensitive, just know that it is done when the music is over. And we are going to code red in 3, 2, 1. Because what the fuck is happening? But yes, Alec Murdaugh is trying to claw back the money paid, or the money he owes to the Satterfield boys. He is trying to claw back his confession of judgment. And then he's trying to get the insurance company to go after the Satterfields. This is twin things happening. I have my comfort coffee. Let's keep going. Mr. Murdaugh is not at Moselle when she falls, but arrives at the scene before EMS. Yeah, because it seems that he was called first. Oh, and he probably used his red lights, right? He probably used his police lights to speed to get to the property before EMS. Because I wonder if his brain was already going this direction once he got the call from Maggie. I have to wonder. On February 26th, Satterfield dies in the hospital. She's survived by her sons. On March 18th, Murdaugh informs Nautilus adjuster that he seeks coverage under his umbrella policy for Satterfield's death. Around that time, attorney John Grantland is retained by Nautilus to defend the claim. What it means when the insurance company is going to defend the claim, it means the homeowner's insurance company is going to say, we are not responsible. But Alec Murdaugh went out and got his buddy, Corey Fleming, to represent the Satterfield sons to sue him. And Alec said, I'm not participating in you defending this claim. I'm going to say it's my fault. And if it's my fault, if it's the homeowner's fault, then they have to pay out. And he knows this. He's a plaintiff's attorney. Getting money out of insurance companies is literally his entire job. But insurance companies defending you means, hey, we don't want to pay out the claim. Look no further than Depp v. Heard a year ago. Amber Heard's insurance company were defending the claim because they don't want to pay out the insurance because she had insurance against defamation. Well, so long as it wasn't intentional, which is why she's being sued by her insurance company because they don't want to pay out, right? They're willing to spend the money to fight her to not pay out. March 22nd, 2018, in a conversation with the insurance adjuster, Murdaugh says that Satterfield briefly regained consciousness before EMS arrived when no one else was around conveniently. And told him, but no one else, that Murdaugh's dogs caused her fall, thereby implicating over $5.5 million in insurance coverage. That is primary coverage of $505,000 under Lloyd's of London and umbrella coverage of $5 million under Nautilus. South Carolina law imposes strict liability on dog owners when their dogs knock someone down, even playfully. So he used the law of South Carolina to his advantage. If you say the dogs are at fault, it's strict liability. Do not pass go. Done. And then it shows the code. Construing otherwise attacked to include playful jumping or pouncing. Providing strict liability for persons otherwise attacked by a dog while the person is lawfully in a private place. March 2018, Corey Fleming begins representing the Satterfield estate for wrongful death and survival claims against Murdaugh. Fleming is a lawyer and friend of Murdaugh who was retained by the Satterfield estate to assert claims against Murdaugh. The Satterfield family retained Fleming because Murdaugh recommended him. I mean, that downplays it, but I mean, technically true. March 28th, Satterfield is appointed personal representative. Tony is appointed personal representative of his mother's estate. March 29, Alec provides a recorded statement to insurance investigator. He says he spoke with Satterfield after her fall and that she indicated that the dogs had caused her fall. Again, this is sus to me because on the 911 and everything else, it said that Gloria Satterfield was not articulable. She was not making sense. And I would need more information about the state of her head injury when EMS got there. Could she have made this statement? I don't know if she factually could have made this statement. But again, the insurance company might have said, if Alec's going to say she said it, even if we can prove that he didn't or that she couldn't have said it, we're still going to lose in front of a trial. Because they were saying that she had a substantial head injury and was not making any sense. October 31st, at Murdaugh's request, Mr. Harriet renounces his right to be personal representative of the estate at Mr. Murdaugh's law office. I thought it was the other son that was the PR. I thought it was Tony. Either way. November 6, 2018, Lloyd's of London Council provides a second comprehensive report regarding the Satterfield fall to insurance adjusters. We have not seen the Lloyd's of London report. We've only seen the Nautilus stuff that was released by Eric Bland. The report states no one witnessed Satterfield's fall. Maggie was inside the house, heard a great commotion on the front porch, came out the front door and found Satterfield laying on the steps, bleeding from an open wound to her head. Satterfield told Mr. Murdaugh, who arrived soon after, that the dogs had tripped her up. Satterfield made no other statement to a witness about involvement of dogs. Satterfield told medical staff at the hospital that she did not know how or why she fell. The report further states that Maggie said that Satterfield's relatives told Maggie that the dogs tripped Gloria up while she was at the hospital. But the Satterfield relatives knew that from Alec. Do we see how the circle works of Alec's statement? Satterfield's relatives, of course, did not witness the fall. No one did. And so that information was simply repeated from Mr. Murdaugh. The report also states, quote, the admitting emergency doctor's notes states she does not know why she fell. The attorney concludes, quote, while there were no eyewitnesses to Satterfield's actual fall at the Murdaugh's home, circumstantial evidence available together with the Satterfield post-incident statement to Murdaugh and relatives suggest the insured's dog or dogs were loose, were near Satterfield, and could have caused Satterfield to trip and fall down the steps and sustain her head and bodily injuries, which were known to cause her later death. I would characterize liability based on what is known at this point as probable but not clear and convincing. You know what that doesn't say? That doesn't say that insurance determined that her fall was based on side effects of her medication. Those two things don't say the same fucking thing. They argue paragraphs up here that her fall was determined by insurance to be caused by medications. And it says down here, well, we didn't see it, but based on everything, the dogs are probably the thing. On November 16th, Tony Satterfield renounces his right to be PR. Okay, there's the second part. December 4th, Lloyd's of London issues a check for the full policy limits of $505,000. That's the one that kind of tipped this whole thing over. December 6th, Fleming receives the settlement check. December 18th, Westendorf replaces Satterfield as PR for the estate. Westendorf is vice president of Palmetto State Bank, with no previous experience acting as a PR. Right, but under the persuasion of Murdaugh, so Murdaugh can get him to do what he wants. None of this makes Murdaugh look good. December 19th, petition for court approval of the pre-suit wrongful death. The timing of this is so fucked, and here's why. December 4th, they get the check. It's a week or two after Tony Satterfield relinquishes his right to be PR. Once Tony Satterfield relinquishes his right to be PR, the only person Murdaugh has to tell anything about the case to is the PR, Chad Westendorf. This allows them to completely cut the Satterfield boys out of this case entirely. They're still supposed to get the money, but they don't have to be communicated with. It's fucking abhorrent. Tracy asked, did EMS or the ER doc say if Gloria said anything? Gloria's statements in the medical records from all the reports and legal filings we have seen is she does not know how she fell or what caused her fall. That's what she told medical. Let's keep going. Ooh, because I only have a half hour. Emily, zoom, or you're not going to get through it. Yes. So November 16th, Satterfield is out as PR by December 6th. Corey Fleming has the check in his hot little hand by December 18th. Westendorf is now the PR by December 19th. The court approves the petition with Lloyd's of London. The petition is never approved, but there is never an approval hearing. There's an undated draft approval from the judge stating it was heard on December 19th. I got questions about what this judge was up to too. January 7th, Fleming disperses $403,500 payable to Forge, ostensibly meaning Forge Consulting LLC, a legitimate company which Murdaugh deposits in the personal account denoted as doing business as Forge. Yeah, fake Forge. They downplayed the fake Forge there. Then this gets set for mediation. Plaintiff Miss Satterfield reported to a neurosurgeon, and then that she fell down several stairs and did not know why she fell. So this is from a later investigation. We know that plaintiff has diabetic neuropathy and had complicated tingling in her feet. We also know that plaintiff was on several medications, including one with side effect of dizziness. In fact, severe dizziness is one of the most serious side effects of one of it. There are multiple reasons why plaintiff fell. In addition to the medications and her diabetes, Satterfield could have simply lost her balance. However, okay, well, they took that a bit out of context. However, Alec has maintained that when he first got to the plaintiff, she reported that one of his dogs tripped her up or somehow caused her to fall. Alec's testimony is the only evidence that the dogs had anything to do with the plaintiff's fall. But for the dogs, there's no insurance payout in this case, is the thing here. So if Gloria fell because she fell, there's no insurance payout. If Alec makes up the lie about the dogs, then insurance pays out, and then he steals the insurance payout. Alec's testimony is the only evidence that his dogs had anything to do with the plaintiff's fall, and he personally feels very guilty about it. So guilty that he deposits all $3 million into his own bank account. Well, not all of it. Some of his friends got the money. So did Alec Murdaugh lie to steal the money for himself? And if he did, is he trying to undo it now? And if he undoes it now, does he not owe the Satterfields any money? He feels guilty about it. So guilty. He needed to assuage his guilt by stealing all of their money. Well, they lost their home. Again, the EMS workers did not see any dogs. We didn't hear any on the 911 call either. And no one said anything about a dog being involved in the incident. No mention of dogs on 911. After the plaintiff's accident, which actually leads me to believe that Alec is probably lying about the dogs, which is not good for the Satterfields, which I don't like. But I think you can come to that conclusion. After the plaintiff's accident and while she was hospitalized, it's our understanding that Alec referred the Satterfield family to his former roommate and friend, Corey Fleming. Corey now represents the estate. For the purposes of mediation, I do not intend to argue liability. I do not see a benefit to Alec to argue that the plaintiff may have simply lost her balance when he says his dogs knocked her down. We're not going to argue because of Alec's statements. However, despite the plaintiff's young age, I do not believe the fall was the sole cause of her death. Her underlying health conditions also contributed. So these are insurance conversations. These are the insurance calculations over how much they want to pay. At mediation, Nautilus agrees to pay $3.8 million of the $5 million limit, far more than Nautilus expected or intended to pay. Nautilus's adjuster blames defendant and is angry with him for causing Nautilus to pay more than is expected because he was going to steal it. No wonder they're suing him for the insurance fraud. At defendant's behest, neither Satterfield nor Harriet were present at the mediation. At Alec Murdaugh's urging, the Satterfields were not at the mediation. You want to know What I think, I bet you do. I'm going to tell you anyway. I wonder if they even knew it was occurring. They didn't know about the $500,000 settlement with Lloyd's of London. Why would they know that there was mediation taking place with Nautilus? At this point, it is my opinion that Alec determined that he was going to steal this money. And he went to mediation to fight his insurance company for his own gain and to commit insurance fraud. And if the Satterfields knew about it, they would be like, where is our money? But they didn't know about it, making it much easier for Alec to steal the money and pretend that he didn't. On March 28th, the Nautilus agreement is signed. April 11th, Westendorf signs a release of claims against Murdaugh as the PR of the estate because the Satterfields didn't have to sign it because they were no longer PR. They didn't need to know. Acknowledging receipt of the settlement from Lloyd's and the $3.8 million from Nautilus. Judge Mullen approves it on May 13th. In a petition prepared by Fleming, which is not filed in court, and is styled in re Gloria Satterfield. May 15th, 2019, Fleming disperses the net proceeds to Murdaugh's fake forge account. So they're just lining out the insurance fraud here. He hasn't been charged with this insurance fraud yet. I don't even know if it fucking matters at this point. He's never getting out of prison. October 5th, 2020, Fleming files a stipulation of dismissal signed by Murdaugh. October 20th, 2022, Fitz News reports the $505,000 settlement with Lloyd's of London. April 12th, 2021, Murdaugh texts Tony Satterfield. 2021. Hey man, just checking in. We heard about this in trial. Been working on a case and made me think about you. Hope all is good. Call me anytime I can help. Tony Satterfield responds, hey man, I'm doing good. How is the case going? Just curious, but how are you? Murdaugh replies, finally getting some movement. April 12th, 2021, finally getting some movement. That money was deposited in May of 2019. Two years? That money was deposited 2 years before this text message saying finally getting some movement, still a ways to go, doing good. Was just thinking about you and thought I'd check in. Hope to see you soon. Satterfield replies, cool, thanks. June 7th, 2021, Paul and Maggie are murdered. June 10th, Fitz News again reports the settlement. September 4th, Curtis Eddie Smith shoots Murdaugh in an attempted suicide. September 6th, Murdaugh resigns from his law firm. And then the timeline gets real fucking crazy from here. Early September, Mark Tinsley refers Mr. Satterfield to attorney Eric Bland regarding a possible claim against Murdaugh. Oh, I didn't know that Tinsley was the one who referred Bland to the... I didn't know that. Because I get the sense that Dick and Jim don't love Tinsley either. Did you get that sense? Did you get that sense at trial? I can see Tinsley and Bland getting along. Could you imagine having a whiskey with those two? Oh, that would be entertaining. September 15th, 2021, Bland files the present lawsuit on behalf of plaintiffs regarding the settlement with Lloyd's of London because they don't know about the other one yet. Imagine how pissed they are when they find out. They don't know yet. Bland took this case thinking this was over $500,000 that wasn't given to the Satterfields, not yet knowing that there is another $3.8 million there. Which tells you that Eric Bland did not go after this for the money. Eric Bland went after this for the injustice of it all, it seems to me, my opinion. Because going after a $500,000 settlement with Alec Murdaugh is not a ton. It's not going to pay the lawyers out a ton. I didn't know the Bland-Tinsley connection, and I'm living. There are no allegations regarding the Nautilus settlement. I imagine it's because they don't fucking know yet. September 16th, Murdaugh's released on bond. September 27th, plaintiffs file a motion for civil arrest. I remember that. October 12th, 21, plaintiffs dismiss Westendorf without prejudice. October 13th, 21, Judge Newman bring the jury. Judge Newman issues arrest warrants for Murdaugh for obtaining property by false pretenses. This is before it all goes fucking sideways. The charge arises from law enforcement's investigation into plaintiff's allegation in this case that Murdaugh misappropriated settlement funds. The affidavit supporting the warrant concerning Murdaugh's theft of the Nautilus settlement and sworn by SLED Special Agent Philip Turner states. So at this point, they know. This is October. On February 2nd, 2018, Gloria Satterfield fell and hit her head at Richard Alexander Murdaugh's residence. Satterfield later had a stroke, went into cardiac arrest, and passed on September 26th. Mr. Murdaugh coordinated with Satterfield's family to sue himself in order to seek an insurance settlement with the stated intent to give the proceeds to the Satterfield family to pay for funeral expenses and monetary compensation for her children. Murdaugh recommended the Satterfield family hire Corey Fleming. Fleming brokered insurance settlements in the amount of approximately $4.3 million. The settlement agreement stipulated that 2.7 was designated for the Satterfield family. Yeah, everything else went to them. And then that 2.7, well, it was more, went to Alec. The Satterfield family were never notified of the settlements nor received any of the proceeds. The settlement agreement was not properly filed in the court of record. The affidavit goes on to describe how Murdaugh stole the funds by having the settlement checks made payable to fake Forge. October 14th, Murdaugh's arrested as he leaves drug rehab. Well, that's not exactly what happened. We heard about it at trial. He's been incarcerated ever since. The warrants became public shortly thereafter. October 15th, Mr. Bland begins a campaign of extrajudicial statements to news media, deriding the character and credibility of Mr. Murdaugh. Was he wrong, though? Just asking. Mr. Bland tells news media it's a stark reality that this is a really bad person. Alec Murdaugh is a really bad person. That's the bottom line. That's the tough pill to swallow. There's no bottom to him. See Mandy Matney, There's No Bottom to Him, unpacking Alec Murdaugh's latest charges. Fitz News, October 15th, 2021. Why is there a ladder outside my window? Hi, Dr. B. October 17th, 2021, Mr. Bland continues his campaign of extrajudicial statements, this time criticizing SLED in an email to CNN. Mr. Bland says SLED's affidavits are not factually correct on a number of fronts. First, those were legitimate claims that were brought in connection with Gloria Satterfield's death. This is where the problem is going to be. Alec Murdaugh is going to allege and is alleging that these were never valid claims. And he's trying to unwind all of this. The death was apparently caused by the Murdaugh's 4 dogs tripping Gloria on the exterior steps of the Moselle home. As a result, an appropriate negligence claim was asserted by her estate against Murdaugh. The claim was not fabricated, and Alex appropriately referred them to an attorney. We know that Alec referred them to an attorney to steal the money. If the dogs did not trip her, I don't know if there would have been a recovery in this case. And that is the crux of all of this, because now Alec's lawyers are arguing that. But that's not the Satterfield's fault. That was Alec defrauding the insurance for Alec's own gain. And then they've cited the report. The warrant affidavits, however, are entirely accurate. Now they're friends with SLED. They weren't feeling SLED. Alec didn't trust SLED for anything the night of the murders. Remember they argued that at the murder trial? That he was so overwhelmed by having to talk to SLED agents and he didn't trust them because they had gone after his friend or some shit. And that's why he lied to Sled. But in this motion, Sled is entirely accurate. Everything Sled told Judge Newman in those sworn statements is true. And Mr. Bland knows this when he publicly castigates Sled for purported inaccuracies. What did you do your entire trial? These are the same. Dude. The affidavits only state that Mr. Murdaugh had coordinated with the Satterfield family, which Bland admits when he amends the complaint in the action 6 weeks later to allege a breach of fiduciary duty against Murdaugh. Bland's statement that Miss Satterfield's death was caused by the dogs and the claim was not fabricated is curious in that the warrant affidavit never suggested anything about the cause of Satterfield's fall, dogs, or otherwise. Reporting on Bland's statement, Will Fulks of Fitz News wrote, quote, an attorney following the case closely told me Bland was, quote, worried about his clients having to cough back up the money to the insurance companies, which they would have to do if the claim was fabricated from the start. And this is what Alec Murdaugh's attorneys seem to be trying to accomplish, other than personally attacking Eric Bland. October 18th, 2021, Palmetto State Bank files cross claims against Murdaugh. October 19th, Judge Newman holds a bond hearing on the two warrants regarding the Satterfield settlement. Bland gives a passionate speech about bond for Murdaugh or against bond. Quote, this is a sad day, Your Honor. It's a sad day for lawyers that we look upon another lawyer who stole money from clients. Alec Murdaugh stained our profession. He also put a black eye on this state. He is a clear and present danger to the citizens of this state and to my family. What did he do to Eric Bland's family? Chat, do you know? I want to know. This man used a pen to steal $3.3 million with another $118,000 that's potentially going to be charged. It's no different than somebody walking into a bank and using a gun. We know he doesn't get bond. October 22nd, plaintiffs move for an appointment of co-receivers. The co-receivers are appointed. Bland continues his campaign of extrajudicial statements. Alec and his family continue to confirm that they have and always will game the system. Is he wrong, though? They don't think decency and the rules apply to them. It's interesting that this is the quote that they chose to put into this lawsuit. I'm just saying. Mandy Matney's sham lawsuit. Alex Murdaugh confessed judgment soon after brother sued him for $90K debt. Fitz News, November 4th, 2021. November 10th, 2021. Bland continues his campaign of extrajudicial statements, this time regarding Murdaugh's habeas petition to the South Carolina court seeking bond. Since the original bond hearing, Alec Murdaugh has taken financial actions which clearly show that he has no respect for the judicial process, legitimate creditors, and victims of his criminal activities, and that the ordinary rules do not apply to him. These financial transactions and how they were manipulated by Alex Murdaugh and those close to him show that in addition, he is also a flight risk, or he is a flight risk. That's from Fitz News, 2021. It's a desperate act by a desperate man, Bland said. In Mandy Matney's A Desperate Act by a Desperate Man, attorneys petitioned to get Alex Murdaugh out of jail from November 10th, 2021. Bland continues his campaign. This is to the Island Packet. Eric Bland, an attorney who with Ronnie Richter represents the Satterfield, said Wednesday he was astonished that Murdaugh now claims settlements by other parties in the case let him off the hook. Quote, you mean Alec Murdaugh gets to keep stolen money because the heirs were so dogged in making other people pay? Bland added, this motion says, yes, my guy may have stolen the money, but I'm declaring the Satterfields are paid in full because somebody else paid the obligation, and therefore my guy Murdaugh gets to keep the stolen funds. Think about how tone deaf and arrogant that is. They said that at trial, right? When they were cross-examining Tony Satterfield, you've been made whole now? It was like, well, you've been paid now, right? Of course, as Mr. Bland knows, Mr. Murdaugh is incarcerated and all his assets are in the receivership that Mr. Bland requested and the court imposes. Now, Now, not then. Mr. Murdaugh cannot, quote, keep any money stolen or otherwise. You were just trying to get it out of the receivership for your legal fees, though. If a claim for damages against Mr. Murdaugh were dismissed because it had been fully compensated from other sources, it would simply mean more money would be available in the receivership estate for restitution to Mr. Murdaugh's many other victims. Except you were also trying to get it for legal fees. But all right. November 18th, Murdaugh is indicted on 27 counts of financial crimes, including 9 related to this matter. He's been indicted repeatedly since then for additional financial crimes and now faces over 100 counts. I think it's 104 at the moment, including tax crimes. November 21st, 2021, Bland continues his campaign. Cool. This is from the Murdaugh Murders podcast, episode 19. Quote, listen, like I said to you a couple weeks ago, there's no bottom to him. He's, morally decrepit and proves it again today. I need Eric Bland to start just quoting VPR. It's what is coming up in the reunion. Inhuman, despicable. Chat, you know what I'm talking about. Demented, despicable, inhuman, subhuman. Thank you, Anika. Subhuman. Yes, they could also call him diabolical. Thank you, chat. Demented, diabolical, and subhuman. I need to write it down. They could also call him a poo-poo head. If you want a little James Kennedy for you. So, morally decrepit, I think goes really well with demented and subhuman and poo-poo head. He stole money from a policeman. He's a solicitor stealing money from a client. That's not bad enough. Let's just go a little deeper and steal from a policeman who does not make a lot of money to begin with. He's going to go, everybody talks about Larry Jean Bell and all these people, Pee Wee Gaskins, and they're killers, and there's no question about it. I don't know. And there is a difference right now, but he is as morally bankrupt as they are. Worm with a mustache. November 22nd, 2021, Murdaugh moves for a gag order prohibiting Bland from making further statements to the media. December 6th, 2021, plaintiffs amend the complaint, adding allegations about the Nautilus statement, adding B of A. We went over that earlier. This same day, Mr. Bland reaches out to counsel for Mr. Murdaugh for the purpose of a confession of judgment. Among Mr. Bland's motivations for seeking the confession of judgment is, upon information and belief, to eliminate the motion for a gag order, which would be made moot by resolution of Mr. Bland's client's claims against Mr. Murdaugh. Of course, a confession of judgment from Mr. Murdaugh would also impede any attempts by the insurance companies to recover the insurance proceeds they erroneously paid out for Satterfield's death, which Mr. Bland has reportedly already said is a concern he has. Are they talking about settlement negotiations? It sounds like they're talking about settlement negotiations. Are they trying to talk about settlement negotiations? You're not supposed to put that in legal filings. Okay. It seems like they're talking about settlement negotiations. Those are This is confidential. Also, how do you know what Bland's motivations are? They're saying that Bland's trying to get around the gag order, implying that he's trying to engage in some kind of a clout circus. Is that what they're trying to say? Let me know what you think they're trying to say. It seems like they're trying to imply that he just wants Murdaugh to confess to judgment so he can continue talking about the case. Oh boy. December 7th, Bland provides a draft confession of judgment. Oh shit. Well, that's absolutely... Emily, keep reading. It gets worse. They make it more clear the further that you go. Mr. Bland provides a draft confession of judgment for $5 million. Mr. Bland states in an email to counsel that he wants the entry of the confession to be delayed because, oh, they actually quote the email? Lord. Emily, keep reading, girl. This is why I didn't read through the whole timeline so we could do it together. Wow. I can't believe somebody's going to make a bar complaint over this if they haven't already. Wow. They quoted the email in the motion. Do they just give no fucks? Like, how many fucks does Alec Murdaugh's counsel give? None. None. This is confidential. It doesn't go into filings. It can't be used against you. That's the point of settlement negotiations. You can't turn around and use it. Oh, Eric Bland probably already has the day this was filed, which was, 2 days ago? On December 7th, Mr. Bland provides a draft confession of judgment. Mr. Bland states in an email to counsel that he wants the entry of the confession to be delayed because this should be confidential. We would like to keep Alec in the Bank of America action for about 6 to 9 months, and we will agree to stay the action against him in part. We don't want them, Bank of America, to remove it to federal court immediately. We can discuss. We have some legitimate reasons for doing this, not just to defeat diversity. Wow. Murdaugh's counsel responds by proposing to change the amount of the confession to 4.1, which is the 4.3 million settlement less the 113,000, which is still in Fleming's IOLTA account. Mr. Bland responds, oh, there's more. Jim, symbolically, it's got to be for 4.3. We are back at all, from 5 million, but I have to have this. It's monopoly money. Oh my goodness. They're putting opinion. It's my opinion. This shouldn't be here. This is confidential settlement communications, it seems to me. And are they doing this to try to make Eric Bland look bad? Because it feels like they really wanted to just use this. Also, Alec is going to have to write just a very brief apology to the family saying that he is sorry for what happened and what he did to the boys and Gloria, and then he takes financial responsibility. Emphasis added. Yeah, you think. Mr. Bland refers to the amount of the confession as monopoly money because the amount of the confession is subject to set-offs for the amounts previously paid by other defendants, which at the time was already more than the amount of the confessed judgment. Thus, the confession would not actually require Murdaugh to pay 1 penny, nor would it give 1 more penny to the plaintiffs. Interesting. Because I don't know if it is subject to set-offs. I have questions. To entice Murdaugh into making a cost-free confession, Bland offers not to oppose Murdaugh's request for bond at the upcoming bond hearing. This offer, of course, was appealing to Mr. Murdaugh, who, within the 6 months prior to Bland's proposed confession of judgment, suffered the murder of his wife and son, and his financial misdeeds exposed. His drug addiction bottomed out. He attempted suicide. He went through drug rehabilitation, and he was arrested and incarcerated, possibly for the rest of his life. Oh, it gets worse. December 8th, Murdaugh agrees to the confession of judgment. December 9th, Palmetto settles with plaintiffs and is dismissed. Palmetto State also dismisses its cross claims against Murdaugh. December 13th, Judge Lee holds a bond hearing. Judge Lee is the presiding judge for the state grand jury. Further, the charges then pending against Murdaugh, bond is in some amount was required under the state constitution. Bland addresses the court on behalf of the Satterfields, states he has recovered about $7.5 million to date for the Satterfields, says he has received satisfactory answers to what happened to Gloria, accountability with Murdaugh's agreement to confess judgment, and an apology from Murdaugh. Bland says he supports whatever decision the judge makes. Bland's law partner, Ronnie Richter, says that the Satterfield family is praying for God's grace to be able to offer forgiveness to Murdaugh. Bland and Richter's statement notes the Satterfield family is, quote, pleased that Mr. Murdaugh has finally expressed his apologies and has taken a positive step toward resolution by agreeing to the confession of judgment. And that, quote, as devout Christians, the Satterfield family is guided by their belief that in order for them to be forgiven by their Heavenly Father, they in turn must forgive others who have sinned against them. Judge Lee sets bond at $7 million. January 13th, in response to the inquiries from Nautilus about a request from the U.S. Attorney's Office, Mr. Murdaugh declines to waive any privilege he may have pertaining to the claim file. March 1st, B of A settles with plaintiffs and is dismissed. The amount is not publicly known, but it is in addition to the $7.5 million Bland claimed in December. March 24th, the co-receivers for Mr. Murdaugh's assets file a proposed confession of judgment to plaintiffs. The proposed confession is filed in the Beach case. The proposed confession admits liability in the amount of $505,000 and $3.8 million, settlements for the claims against him for their complaint. In this action, subject to set-off amounts recovered from other defendants. Those set-offs already exceeded $4.3 million, meaning the confession did not create any obligation to pay. I need to go look at the set-offs. The confession states no facts whatsoever constituting the confessed liability, nor does it show that the sum confessed does not exceed the liability. You were his lawyers at the time. April 5th, Mr. Fleming and his firm settle and are dismissed. The amount is not publicly known, but is in addition to $7.5 million Bland claimed in December 21. April 22, 2022, Nautilus files a complaint in federal court seeking declaratory relief against Murdaugh with regard to the privilege. We've covered that. May 12th, Nautilus's original claim for declaratory relief is dismissed without prejudice as procedurally improper. And then they file a separate claim. Murdaugh executes a confession of judgment May 27th, 2022. May 31st, it's filed. July 17th, Murdaugh is indicted for murder. January 13th, the Nautilus action is stayed pending the murder trial. January 23rd, the murder trial begins. That feels like 100 years ago. March 2nd, Murdaugh is convicted of murdering his wife and son. March 3rd, Murdaugh is sentenced to 2 consecutive life sentences. May 1st, Murdaugh files an answer in the Nautilus action. In his answers, he admits he invented the story about the dogs knocking over Satterfield for the purpose of causing Lloyd's and Nautilus to pay to settle a false insurance claim, and that he stole the settlement proceeds by persuading others to disperse funds as checks payable to forge, meaning fake forge. Legal standard, Rule 60B. On a motion and upon such terms as are just, the court may relieve a party or legal representative from a final judgment for the following reasons: fraud, misrepresentation, and other misrepresentation of an adverse party. The judgment is void. Here's the thing. Murdaugh is not an adverse party. It's his own fraud. He's not adverse to himself. Whether to deny or grant the motion lies within the discretion of the judge. What other fraud other than Murdaugh's own fraud? Wow. Oh, man. Oh, I am covering the document. Miguelina, let me take a look at that in a minute. And I know I'm coming up against my hard stop. I'm gonna zoom. Thank you. The South Carolina Appellate Court does not define other misconduct, but other state courts have. Other misconduct of an adverse party. They're trying to say that the misconduct is Eric Bland's, not Murdaugh's. The confession of judgment should be set aside because it is void. The outcome of a pending lawsuit is a contingent liability. The statute therefore requires a confession of judgment in a pending lawsuit to state the facts constituting the liability. It does not do that. I agree. And show the sum confessed does not exceed the liability. They're saying it is factually flawed. Isn't that their own malpractice then? Isn't that their own problem? That they were the attorneys representing him in the confession of judgment, and they are now saying it is fatally flawed because it does not meet the requirements. Here, the confession at issue states no facts. I wonder if that's why they put out that Eric Bland wrote the confession of judgment and not them. It merely states debtor admits liability. That's true. Nor does it show that the sum confessed does not exceed liability. In fact, it did exceed liability by $113,000. The remainder of the 4.3 million. Mr. Bland was not concerned about this issue because, in his words, it's monopoly money. The amount, in Bland's words, was merely symbolic. The reason the legislator enacted the statute regulating confessions of judgment and pending lawsuits is to avoid exactly this situation where a symbolic, fact-free confession of judgment obstructs the adjudication of claims involving multiple claimants by favoring one victim over others. I need to read this case law. They were the attorneys that advised him on this. What are they going to say? Well, we didn't know that the dogs didn't trip her at the time. A void judgment is one that from its inception is a complete nullity and is without legal effect. The fact that they're going to have to keep fighting this is just wild to me. Were they holding this? Were they holding this as a get out of jail free card? Were they holding this knowing down the road they would try to withdraw it? Like, hey, we'll let it go. We're not paying any money, so we will let it go. But we want to do the confession of judgment to use this in the murder trial. He had not been indicted yet for murder. I wonder if they knew it was coming. I think that they did. And then in the murder trial, he can say, hey, look, but I admitted to all of these things. And now he's saying, no, but it was done wrong. Pull it back. He used it in the murder trial to make him look like a good guy. Woo-wee. This is wild. And they're arguing that the result is inequitable. Plaintiff's counsel has publicly asserted that Mr. Murdaugh should not be allowed to keep the money he stole just because plaintiffs recovered restitution from third parties. He makes that argument on social media rather than in a courtroom because he knows it is nonsense. Mr. Murdaugh keeps nothing. This civil litigation will not affect his quality of life in any way. Mr. Murdaugh is in prison perhaps for the rest of his life. I think that is probably what's going to happen. In protective custody because he may be killed if he's released into the prison's general population. Every asset Mr. Murdaugh has is in the custody of receivers. Every asset that people could find or know about is in the custody of receivers. That's my opinion. Bland asked the court, in the hands of the receiver that Bland asked the court to appoint. If Nautilus obtains a judgment against Murdaugh for $3.8 million with no offsets for the third-party recoveries Mr. Bland has obtained, the only effect will be to reduce funds available to Mr. Murdaugh's many other victims. The Satterfield family is, unfortunately, not the only victim of Mr. Murdaugh's actions. So what, now they're standing up for all the other victims? Mr. Murdaugh makes this motion to correct the record in this matter, which he is obligated to do, so that those victims might receive restitution according to their rightful share. Signed, Dick and Jim. We've got to do one more thing real quick before I have to go. If I don't get to everybody's questions, I will do more questions, I promise. This is wild. It seems that they are looking for a do-over. And the judge is going to have to really look at the procedural part of it and see if the procedural part is a problem, even though all the attorneys signed off on it, if it's fatal, if that procedural is a fatal issue. Bland Richter has made a press release about this and did pretty quickly after this motion was filed. I wish they would date their press releases on their website. Bland Richter, could you date your press releases on your website? It makes it easier to report on them. Okay, thanks. I should just tweet it. Bland Richter's response to Alec Murdaugh's May 16th motion press release. It would help if this was dated. Alec Murdaugh's May 16th motion is yet another frivolous court filing that Dick Harpootlian and Jim Griffin have filed in the multitude of civil and criminal actions on behalf of their client, who is a liar, a thief, and a twice convicted murderer. Well, first, shockingly, they reveal confidential settlement discussions they do in violation of South Carolina court rules in their filing. This violation needs to be investigated immediately. I'm sure they've already made a motion about it or made a complaint to their state bar. They also seem to attribute thoughts and motives of others like somehow they have telepathy. Okay. In addition, they are simply factually wrong about the timing of the settlements that the Satterfields obtained from other parties. They might actually not know that. This motion is nothing more than an endless and nonstop prattle of sore losing lawyers. We welcome addressing these arguments in court. Oh, I can't wait for it. They have lost almost all of the meaningful motions they have filed on behalf of their miscreant client. I'm not here for the name calling, but maybe you are. I don't know if it's needed at this point. But I understand the personal affront because Bland Richter is, both of them are probably fucking pissed at this point. So, you know. Oh boy. They have lost almost all of the meaningful motions they have filed on behalf of their miscreant client, Alec Murdaugh, over the past 2 years. We are confident this most recent motion will be another loser. For example, their current motion does not come within the requirements of Rule 60B to obtain the relief they thought they sought. And they do not have standing to make these arguments on behalf of other settling parties. This is a classic case of buyer's remorse. It might well be. Alec Murdaugh gave the judgment for reasons only him and his counsel knew at the time in May 2022. Now they seem to be singing a different tune. We're not all singing from the same sheet of music anymore? Shocking. I wish they had used Poot's words against him, but that's okay. Now they seem to be singing a very different tune from a different sheet of music. The very attorneys filing this frivolous motion advised Murdaugh to sign the confession of judgment they now seek to vacate. A very good point. This is personal, seems to be. Dick and Jim are improperly utilizing the judicial process for ulterior motives that are meant to harass and victimize the Satterfields again, and constitutes vexatious conduct. I don't mind these attorneys taking shots at us. Comes with the territory. This sounds like it was voice to text. They are upset that they do not get $160,000 from Murdaugh's appeal as the result of arguments that Bland Richter recently made. They are nothing but paper bullies. We will continue to fight them in every courtroom in the land and obtain justice for our clients and stop their gaming of the system. It feels like gaming of the system. They agreed. They agreed to the confession of judgment and now are like, just kidding. We didn't want to do that. No take backsies, I guess, is where we're at with all this. Y'all, I wish I had more time to distill the thoughts on this. I'm interested in the procedural part of this because if there is a procedural deficit, if that could be cured without undoing the entire confession of judgment, it does feel personal. Does it feel personal to you? It feels like there is beef with these attorneys. A lot of it at this point. And it felt like that at trial too. It feels like there is a lot of bad blood. Yes, because baby, now we got bad blood. It feels like there is a lot of bad blood between these attorneys and Tinsley and Bland. It feels like the tide in South Carolina legal is changing and that we have two very distinct sides between the old boys club and the new wave of lawyers. And it feels like there is a shift in the power in this legal community, and they are fighting. And Tinsley and Bland are fighting. And Dick and Jim are pushing back. Times are changing, man. Dick, Jim, not legal advice. Go binge watch VPR. Because Tom and Tom thought that they would get the same treatment that they always had. That everyone would be like, oh, Tom, you just cheated a little bit. Everyone believed you about Miami Girl. It's fine. And instead, times have changed. and they lost. And they still seem stunned that everyone's big mad about it. They're like, I don't understand why everybody's so mad. It was fine a couple years ago. Times have changed. What was fine a couple years ago is no longer tolerated because it wasn't fine then, it was tolerated. And we can talk about the structures of society that made that the case, but we're not going to do that today because we do not have time. But it's not being tolerated and it's being brought into the light. So if you think what used to be fine is still fine, it is not. Unless it's 90s fashion, still good. Same with music. That's all fine. So go binge watch VPR and watch how it changes. Because they did not expect, the Toms did not expect the comeuppance that has happened. But times change. And it is going to be real interesting to see how times are changing for Alex Murdaugh's lawyers. They're holding on to a power that they seem to no longer have. And the legal community in South Carolina is on notice that there are attorneys that are going to shake it the fuck up and that are not going to rest and that are going to call it out on podcasts, in the media, in the newspaper. They aren't going to be dissuaded by the old boys club. So I'll be interested in the procedural part of this, but it doesn't seem like the procedural part is the real fight here, does it? This is a fight for power. And this is a fight for who and how the South Carolina legal community is going to move forward, isn't it? And that is going to be very, very interesting. Because these attorneys aren't going to be intimidated at all. And they're not going to back down. And they're going to continue to fight this on multiple fronts. And some of those fronts include in the media. They are going to use that to their advantage. Because with the media, the old boys club can't just keep doing the same old things. Because now everybody is watching. I'm going to get to a speed run of questions for just a moment. And then I have to go. I'm sorry. I really wanted to talk about the Supreme Court earlier today, and I knew we had a lot to get to with this. I added way too many stories because time is a construct. But if I'm late for my nail appointment, I'm going to feel really bad. I'm trying to be on time. So real quick. The helpful stranger said sad because I bet he did lie about the dogs. He very well might have. So what did happen to Gloria if it wasn't the dogs? It could have been that she just fell. I don't know. But whether or not that's going to undo any of the rest of this, I also don't know. We need an opinion session, SCOTUS deep dive. I think for fair use, we do. Kim said, I'm not a big makeup person. I wear it on special occasions. However, I just ordered Allegations and Shade and I'm very excited. The lip glosses sound so fun. Fun and wearable for every day. Philip Kane, will this affect YouTube reactions channels? I need to read. I don't know yet. I don't know yet. I thought I was the only one who knew about my Salvabard peeps. I think I said that wrong. Salvabard peeps. No, apparently a lot of the chat loves them. Some Salvabard. Loved your chat with Annie Elise. Thank you so much. It was a lot of fun. And I've shared that on my community tab if you haven't seen it. Wife and I renewed vows at 10 years. We'll be married 19 this October. Can go okay. No. The rule only applies if you're on a reality television show, The Helpful Stranger. It does not apply to real life. It only applies to reality TV, particularly Bravo reality TV. So reality TV is the problem. Jen Gerard, good to see you. Just wanted to say huge thanks to you and the Law Nerds for being so excited about this collab. We have a ton of orders, but we'll get them out ASAP. Funnest project ever. Love the Law Nerds. Jen, love you. Love this project. Where did I put it? I love this so much. It's going to be right back there on my shelf with my StreamYard duck because everything I do is recorded on StreamYard. And the makeup I wear is Gerard Cosmetics. The lip gloss I wear all the time is Gerard Cosmetics. Other things I change up here and there, but I love it so much. I love it so much. Love it. Love it. Love it. If transformation equivalent to basically a print with an IG filter negate copyright, we'd have more precedent issues. A fair point. A fair point. Tana and Jake is a deep cut. It seems like a billion years ago. Wasn't the internet simpler when everybody was trying to find out if the Tana and Jake relationship was real or fake? What didn't we live in different times, simpler times, when like drama in YouTube was like somebody wasn't in a picture and there was like a shady tagline and like maybe a middle finger. Like that kind of drama felt light. It didn't feel like messaging minors. It like the internet got heavy. Well, the internet was always heavy, but internet drama got heavier. Side note, blown for good, Claire Heady, who was an expert witness for the Masterson prosecution and growing up in Scientology, Aaron Smith have both mentioned they've emailed you for interviews. We would love it. I will talk to my team. My team gets all of my emails. We have been swamped with requests, so we would. I will absolutely take a look at those requests. I have some time off coming, so it has been my interview requests have been getting pushed out into like July right now. Kiana Bunch, I'm graduating law school with honors today. I'm a fellow ADHDer plus other BS. I mean, same. And want to be a DDA. Thanks for reminding me that I can do it all. You can do it.
Don't be afraid to ask for help. You've got this. Woo!
And congratulations on graduating with honors. Make sure to keep your balance and sleep. You need to sleep. Don't sacrifice sleep. Your brain doesn't work when you don't sleep. Also hydrate. Ohio Palm Mom said, why would Dick and Jim care? Nothing has come back on them yet. It's a fair point. I wonder how disclosing settlement conversations in a legal filing is going to go, though. Courts tend to get real sticky about some of those rules. Real picky. Real picky. The rules are there for a reason. Stick to the rules. Rob, did you catch the part where in Murdaugh's latest motion, his lawyers were quoting emails that were settlement negotiations? Love to hear your thoughts on that. Oh gosh, I have to get going. I am so excited to see all of you loving this collab. If you are ready for your own collab, the links are all down below. The links are on Nightbot. You can use code LAWNERD to get your discount to go get your collab. It is live today. And I cannot wait to see how you like it. Absolutely tag me when you get them on social media. I've seen so many of the tags. I'm going to go out and share them. Don't forget your code. Hit the link down below. And if you want to make sure you get an email with all of the information in it because you're like, I can't hit a thing, I'm going to forget a code, just sign up at Law Nerds Unite. You will get an email telling you how to do the things. I appreciate you guys. Thank you for your support always. I intend to cover Monday's Koberger hearing. So if you want to know when I'm going live on my non-usual live times, you also need to be signed up to lawnerdalert.com. I need to decide what time I am doing that. I need to figure out how the media is getting that released. It seems to be on a delay, but hopefully I will know more at the end of the day or at the end of the week at least. So I will keep you up to date on Law Nerds Alert and on social. And with that, I've got to say goodbye. I appreciate all of you. Today was a ride, man. We had a lot to cover and we did it. To all the grads, happy graduation. To the rest of you, get ready. Get ready for summer. Get ready. Go get your Law Nerd lippies. It's time. It's perfect for summer. Okay. Bye.
You can find all the Law Nerd goodies at lawnerdshop.com. Connect with me on social media at the Emily D. Baker. And don't forget to check out my podcasts, The Emily Show, and the new podcast, Quick Bits, summarizing everything I talk about on my Tuesday and Thursday live streams. You know, when you only have time for just the quick bits.